Mr. Kramer.
Thank you, my Lord. Just on the 2016-2021 point, you'll remember what I mean by that is the inconsistency. I don't know why, but we never took it in our grounds or skeleton, so I accept that it can't be a separate ground of challenge. Nevertheless, I think it's indicative of the lack of coherence of the outcome that was ordered and is an attraction of our outcome to the appeal. But I accept it can't itself be a challenge to the finding.
Yes, I see that.
My Lord, Harbert's plasticine is at Authorities tab 8. It's a well-known case mainly for exclusion clauses. That's not what we're talking about. It's about the defendant's negligence in installing a wax storage machine in a factory, and that led to the factory burning down. It's at 179 of the bundle, and the relevant finding is at page 181 in the held note, paragraph 3. And it's the lack of an allowance for a benefit of betterment for having a newer rather than older factory. I'm going to explain why that's relevant in a moment. If we just go to 205, we can see how the point was concluded by Lord Justice Widgery at the top paragraph. If you just read the top paragraph from about 8 lines down, it says it was clear in the present case.
So page, give me the page again.
Page 205 at the bottom, and it starts at about B. So, new factory, more modern design and materials, therefore worth more, but no need to give credit for that because it would be forcing them to invest their money in modernising their plant, which they didn't want to do. And then, as with most things, I can make the points on that case better through the words of Mr. Justice as he was legate. And if we go to the Thai Airways case...
It's good enough for us to see the one judge, is it?
It is. The points, yes, it is. It's quite a simple finding that essentially that it was reasonable to buy this factory. You couldn't have bought a factory that wasn't better and that wasn't new. When you're replacing old, you're always going to get new. And should you have to give credit for the increased value of that new, the answer is no.
And just to be clear,
yes,
I was dancing on to Lord Justice Cross.
Yes.
I'm going to be back to the Master of the Rolls. He ends up by saying that the defendants didn't call any evidence to make out a case of betterment. Now, was that key to his reasoning or not?
I don't think so, for reasons that I'm about to show you in the explanation of Mr. Justice Leggett, which is about the principle of it. But
well, it does seem to be, if you look at page 208 at the top.
Yes, indeed. Well, there the point is about, can you apportion the cost? So you've paid more, the claim was for the cost of replacement. You've paid more to replace than you would to get something old, essentially, because you've built a new factory. Can you apportion the cost in some way? And then it said, well, if the factory was better in a way that was avoidable, then you perhaps could, because you'd have to say, well, the only reasonable part of your replacement cost is the cost of a replacement, and if you decide to upgrade it, that's an additional cost that's not recoverable. And in that case, you would have to apportion it. So,
yeah, he says, but the defendants didn't call any evidence to make out a case of betterment, and we were told that, in fact, the planning authorities wouldn't have allowed the factory to be rebuilt on the old lines. So it's just, there was no option.
There was no option. But, exactly, so it was reasonable to do it, and there's no betterment, because although there was no option, there was also, as we'll see, no pecuniary advantage that can be crystallised, because nevertheless, the assets of the claimant were plainly increased by the new factory. They had no option but to do it, but they did it. And then the defendant has to pay for that by paying for the new factory. There's no option. But why
There's no option. They couldn't build a less valuable factory. They
No.
had to build a new one, in fact. They weren't deliberately building one with extra storage space and roof
Yes.
gardens and
Totally.
a business suite. It's the least best new thing they could do, if you follow me.
Same in my case.
But if they had a choice, and could have simply bought second-hand kit and put it into an old factory, which would have been the exact functional equivalent to that which is going down
Yes.
on one hand, and had chosen to build a new one with new equipment on the other,
You could only recover the lower cost.
because they would have had a commercial choice as to what to do.
Absolutely. And in my case, we have a revised development scheme that cost more to build, but it was a reasonable thing to do because Waitrose had left and there were the difficulties that
And
there were.
there's no appeal on that point.
There's no appeal on that point. But the point that's made is nevertheless you have to give credit for the increased capital value of your new, which you couldn't have avoided, development. And the question is that right? And I'll show you why it's not. So, my lord, if we go to Authorities Bundle 2, it's tab 17, it's the Thai Airways case. Now that case is about the supply of seats for aircraft, but Mr. Justice Leggett had cause at, if we go to page 590 at the bottom, so the bundle page 590, had cause to consider these cases. We see
It's a difficult case to understand this. What did he mean by betterment? What, in inverted commas, was the betterment here?
Do you mean Thai Airways or the...
Yes. Thai Airways.
Yes.
I've got a definition of what counsel thought it was at 64.
Yeah.
Its profits as a result of leasing the replacement. They took 3 aircraft, I think, from Jet, because the seats for their own aircraft hadn't come.
Yeah.
And for reasons that aren't clear to me, insofar as Thai earned any profits as a result of leasing those 3 aircraft, which it wouldn't have earned if it had not been necessary for Thai to take those steps, Thai need not, as a matter of law, give credit for such betterment. That seems to be the argument, and the betterment there is the extra profits they'd have got from having, I don't know if they were bigger aircraft or whatever it was. But that's the betterment, is it?
Yes, it's profits. The betterment in Thai Airways
It's profits.
did have to be accounted for because they just made more profits. You can see that at the end of the section at 82. It was a bad argument, ultimately.
And that's what they're talking about there.
We had to do something, but we didn't have a choice but to do it. So we shouldn't give credits for our increased profits. And Miss Justice Leggett said, well, of course you should. Same our case. If in fact the revised development scheme had produced greater net profits, so rentals even allowing for finance, then we would of course have to give credit for that. But why not the capital value? And the answers are given through Mr. Justice Leggett's explanation of the case law. Paragraph 67, he considers Harbert's plasticine. We don't really need paragraph 68 to 75 because they're a bit more about the point of what if you choose to upgrade in your replacement when you don't have to, and that's not our case.
Sorry, could you just...
Yes, Madam.
A moment ago, you said you made a proposition that you would have accepted. You said if the revised
Yes.
scheme had resulted, then why not? Can
Yes.
you just run that one past me again?
If our the revised scheme made a greater amount of, if you net present value it, a greater amount of rental income than the other scheme by 2.5 million,
Yes.
but it had increased finance costs of 3 million point something,
Yeah.
meaning that overall there's not a net profit in the new scheme in the sense of profits here, profits of running the business. But let's say the rental income had increased so that the net present value was up by 5 million on rent, but was only an increased finance cost of 3 million, then we'd say, well, we would have to give credit for the 2 million because going forward into the future, and the net present value is just a capitalisation of the future, going forward into the future, we make greater profits under this scheme, as we did with the Parsons machines.
Okay.
Yeah, so that's the point, my lord. And then, so if you go forwards, up to 75 is about gold plating where you don't need to, essentially, in your replacement. And then at 76, there's a rationalisation of the cases which we say is right, and it's essentially determines when you have to give credit for a benefit under the betterment principle or not, and when you don't. And 76 explains that where you get money, not notional value, money.
So money in the sense of cash in your hand?
Yes, profits in this case. Thai Airways, it was profits. In my case, it would be rental income. In the example I just gave to my lord, if the rental income was increased as against costs, there'd be greater profits.
So, I mean, leave aside your point about what you were going to do with this property.
Yeah.
If you get a much more valuable asset, is that a pecuniary benefit or not?
No, it's not. I'll show you it's not.
Well, that doesn't seem to make much sense. I mean, why should it depend on whether or not you have to sell the property to realise the cash?
Because it does, because you're not in the business of selling property.
But that's
so
a
why
different
make
point. That's
you...
not about pecuniary benefit.
No, it is. Let me
Is it?
show you, my lord. So 76 says if you get money, and in fact that disposes of the Thai Airways case because they just got some profits from using the aircraft. And then at 70, you can go forward to 77, says that here there's a pontoon that had the new pontoon had a longer life. So and we're going to look at that case, but so that meant that the replacement would not have to happen until later, which meant a real pecuniary advantage, which is what Lord Justice Rick says. And then we see in 78...
Sorry, can we just pause
Yes.
there? So
Yes, my lord.
77.
So you've got a pontoon that's going to run out in 8 years, but you have to replace it because it's burnt down or whatever happened.
Yes.
And then you get one that's going to last 30 years instead.
And you have to give credit for that.
You have to give credit for 8/30ths of it because in the future you will be replacing... We'll come back to that point as well. In the future you will be replacing it, and so you will have a cost. And you're now saving that cost for 8 years. So that's why he says there it's a real pecuniary advantage. And then in 78 it's explained. First in Westinghouse and in Baltic Surveyor, there were monetary benefits in the future. This is not your patrimony is increased by an asset value on your books. This is pecuniary benefit in the future. Savings in the future in Westinghouse, I spend less on coal. Baltic Surveyor, future payment. And then in 79, the claimant did not obtain any pecuniary advantage in Harbert's plasticine. The plaintiffs acquired a new factory which may have had a higher market value than the old factory, which it replaced, but in circumstances where the plaintiffs had not wanted a new factory, had no known plans to sell it, this did not give them any more money. The position would have been different if it cost less to run, because then there would be money in the pocket or in the profit and loss account. So insofar as it can be demonstrated it was going to be realised in cash, credit would have to be given.
Do we find that in the case? In Harbert's plasticine?
How do you mean, my lord?
Well, the distinction is drawn according to whether or not you're going to have a cash advantage in terms of reduced costs. Is that in Harbert's plasticine? Do they draw that distinction?
Well, that's what it's all about. They need to save money with... Oh, in Harbert's plasticine, the factory. I
mean, if this is the explanation of Harbert's plasticine, do we find it in
the case, it wasn't argued that the new factory made more money. The question is the new factory worth more? Irrelevant, my Lord Mr. Justice then Legate says. Irrelevant because it's a bit like the unjust enrichment principle of incontrovertible benefit. So you've received a benefit, but unless you're cashing it, you can't be made to cash it, and you can't be made to give credit for it because your business is not to sell it. If it's an asset you intend to sell, then that's a different matter. And that's
I was going to ask about paragraph 81, and you've preempted paragraph 81, but I think all of this comes down to what is the nature of the business stroke asset that Barrowfen earns. But it's 81 gives the definition of monetary benefit, which is money or which the claimant could reasonably expect it to realise in terms of money. And that takes us straight back to the argument we had this morning, I think.
It does a little bit, but you see at the top the point was that there's no intention, no known plans to sell, and so this goes beyond could, because all the judge had, all Mr. Stewart has is could. Why? Because it wasn't put to Mr.
I think it still comes down to the one question: do we regard this as a business which generates income for the trust, or do we regard it as a business which holds one single property for long-term rental?
I mean, yes and no, my lord. That binary, obviously I characterise it the way I characterise it, but I think that's unfair to our case for the reason that businesses are more complicated than that, and really the question is, could you be reasonably expected means should you have sold, not just could. So if you examine the business through cross-examination and say, well, Mr. Patel, do you have plans to sell it? Why not? Didn't you value it? The answer is no. There was no valuation in 2021. You should have sold it. I could have reasonably expected you to sell it. Now, it's a bootstraps argument to say, well, you should be reasonably expected to sell it because you can sell it. You need something more than that. Now, my lord says, well, it depends on how I characterise the business. If it's a selling business, then
well, there's something more. Question one is, do you want to get the best for the family? Yes, of course I do. If somebody offers you the Westfield Shopping Centre for Tooting, would you take it? Gosh, I'd bite his arm off. Summarising the more erudite cross-examination that would have come. That's the problem that I've got, actually, is whether I agree that you see this as an asset like a factory to use things, or whether it's simply a means of raising money for the family. And you say that's an unfair characteristic. And I've got your submission, so don't worry. It's a question of whether I agree with them.
Mr. Harbert.
And I haven't decided yet, so don't worry about that either.
Mr. Harbert, I see you're in the plasticine business, but what if someone had come along and offered you £100 million for your business and factory?
Well,
well, of course I would have taken it. I don't want to be in the plasticine business anymore. I want to be in the lying on the beach with a cocktail business. Yes, of course. But that's no good. And the questions weren't put.
Yeah.
Not like that. They were put, could you have sold? Yes, of course.
But I've got your submission. I haven't decided.
I understand, my lord. I understand, my lord.
I'm still struggling to think what the question is, and then I'll worry later, over the summer, no doubt, about the answer.
Well, maybe with a cocktail on the beach. My lord, the distinction that my Lord Legate, Mr. Justice Legate, makes is a clear one. It's that where you improve things, it's only if there's a pecuniary advantage to you that you have to give credit for that. And if you do get pecuniary advantage, then you do have to give credit. And pecuniary advantage does not mean a book value benefit. It means cash or imminent cash, as in intention to sell, known plan to sell. It might even not be imminent. Imminent's wrong. Future would be fine. As in the pontoon, you're going to have to renew the pontoon, and now you've delayed that for 8 years. We'll come back to that in a moment, because my little friend takes a point on that. But it's important, we say, and it's exactly to my Lord Justice Newey's point, that it does come back to plans to sell here, intention. Because if you're intending to sell, you're in the selling business, then you've got a pecuniary advantage by being given a more profitable item. It doesn't really matter whether you sell it or not, actually, because you're in that business. And ultimately, you'd be deemed to sell it. So the questions run together.
So is it right that you say, in fact, the claimants, Barrowfen, could have redeveloped the property in this case in any way they chose, at whatever cost, and not given any credit for the enhanced value?
Well,
because
no, my lord, because they have to do it in a reasonably mitigatory way. So if they have a choice and they go for something that's optionally greater than the original one, optionally because they have the choice, not in my new reality, I've got Lidl instead of Waitrose, which is literally what happened, I think. And I've got new planning and I've got different costs because concrete's more expensive, etc., etc. This is what I do. And that gets shaken down in the argument about whether you took a reasonably mitigatory step. And you saw that there's a lot of argument sometimes that you gold-plated it and they say, no, this was the only thing I could do. But if all you could do is what you did, and it's said to be reasonable, well, the pass is sold there because you did it, and all the costs are recoverable, and all the profits are to be taken into account, including all pecuniary advantages. It doesn't matter how much you spent or what it's worth, if you're never going to sell it. Of course, that's not as unreasonable as it sounds, because the more it's worth is because you're earning more rent off it. So ultimately, those do have to be taken into account because you're in the renting business, or the plasticine business, or the...
You talked about unjust enrichment a moment ago.
Uh-oh.
I half remember from unjust enrichment somebody long ago saying, somebody cleans my shoes, what choice have I got but to put them on? And there's sort of that
Yes.
idea.
You see that in paragraph 80, I think. I mean, that's a case where one didn't freely accept, so there's a slightly different point. But if you don't freely accept, then the question is, did you have an incontrovertible benefit? And on this, you'd say the answer is no, I've got no pecuniary advantage. Obviously, if you freely accept, then you're enriched. And if it's incontrovertible benefit, then you're enriched. But in paragraph 80, it's the example of somebody who has to go first class because he doesn't have a choice. And so, in a sense, he hasn't freely accepted. It's not exactly that, obviously, but it's the only option. And so then you switch to incontrovertible benefit. Did you make a pecuniary advantage? And the answer is no, because I just had a more comfortable time with a bit more legroom, which is not pecuniary advantage. So the focus has to be on profits of the business as run. The actual, of course, if they had sold, you could say, well, that's a pecuniary advantage, so you have to give credit for that, unless it's, for its own reasons, breaks the chain of causation. I think I should, on this point, touch on what my learned friend says in his skeleton, which is at paragraphs 70 to 78. I'm glad we've left on just enrichment. Well, more came back to me than I thought. I'm sorry I don't have the bundle reference.
C77.
I'm sorry?
C77.
C77. Thank you. So we see, this is the section in which my learned friend deals with the betterment cases. And at 70B, he seems to say it's different because you're reducing a credit rather than reducing damages. Well, we say that's just words. In both this case and the betterment cases, you're considering whether damages are to be reduced by reason of a credit that needs to be given, or not. And interestingly, at 71 onwards, Mr. Stewart seems to accept the question is whether there's a pecuniary benefit. He says this in 71. And then I think his answer is that there is one here. I'll just find that for you. So just jumping forward at 78, he says the investment, third sentence of 78, that investment which it continues to hold is a true pecuniary benefit to the company. So he's accepting the test, but he's saying, well, you've got a better scheme, you've got a better development, and that's a pecuniary benefit. And we say, well, that's just wrong on the case law. He mainly relies on the Baltic Surveyor at paragraph 72 to 74, because he says, well, there wasn't an intention to sell there. If we look, so we should look at that authority briefly. It's at tab 20. Of the authorities, page 672, and it's at paragraph 85. If you just go down to the bottom of the page 672 of the bundle, and you see the last 3 lines. So in the case of replacement buildings, and you go over and he this is Lord Justice Ricks, talks about how the newness may not matter, and then he says halfway down that paragraph, if the bigger size with real pecuniary advantage to the claimant, as my learned friend asked where I am, so perhaps my lords are thinking the same. I'm about halfway down the paragraph at the top left of 673. If the bigger size were of real pecuniary advantage, as where he was able to sublet extra floor space, in an example, that's obviously not the Baltic Surveyor, but in that example, don't see why that should not be taken into account. So if you've got a business you're letting and you can increase your rental income, then that's a pecuniary advantage. We say yes. And then going down to the bottom, if you look at 88 and 89, there's a question about the replacement. And the question is, how do you value the destroyed pontoon, which is a slightly different question that arises in destroyed tort of destruction of property. And then if you go down, so there's a bit of discussion about how you value a piece of property. And if you go down to, that's been destroyed, if you go down to 91, it said, there's some discussion about the relevance of Ms. Voden's intentions with regard to replacement. The judge said it was appropriate to assume she would have replaced the pontoon, but didn't make a finding otherwise. And then he says, well, it's accepted that this is an appeal on the point of law only, not on that finding. And therefore, I don't think it would be right to allow the question of intentions to enter into discussion. And I'd merely point out that there was no finding, and the parties have an argument about it. So my learned friend says, well, there's no intention here. The judge just assumed it. And that's right. But because that was unappealed, Lord Justice Rick says, well, I just can't go behind that assumption. My learned friend, therefore, doesn't give a fair reading to say this is authority for intention not being necessary or relevant, because that's not what happened. It was just a lack of a factual appeal against the assumption. And in our case, obviously, we have a factual finding that it was intended to be held. So, my lord, I'm going to move on to the more classic breaking the chain of causation cases. But we say these cases of themselves and through the principles show that the core is whether there's a pecuniary advantage. And that depends on an intention to sell, or more typically on actual cash, which is how you get profits in your trading business. And this business did make profits It just so happens, it's an accident of the facts and the valuations. It just so happens that when you look at the future income streams, the new development was worse than the old one. And it might not have been, and then there would have been pecuniary advantage. Just before we go to the new flamenco, which we're going to do in a moment, there's just to go back to the market measure principle through the Stanford case as a useful summary. That's at tab 16 of the authorities. So it's page 524. The facts don't really matter, but they're actually about Queen's care duty, which is not relevant. I agree with my learned friend. But if we then go to 542, we see Lord Legate now, a paragraph 43 says, well, there's no presumption of breach date, and then goes on to explain a principle that's familiar, I think, to us all, that the reason why one often values at the breach date in sale of goods cases especially is because of the rule of mitigation. I.e. the available market, etc. And so that obviously presupposes that the rule of mitigation or causation requires you to...
Sorry, I've lost where you are.
it's just 43, which is quite a long paragraph, and I was really talking over it while I was suggesting you might skim it yourselves. And he explains what's sometimes called the date of breach assessment as being based on market mitigation rule where there's an available market. And then if we go to 45, I don't want to get into the golden victory because it's got some complexities, and there was obviously a 3-2. But if we just read that short paragraph, you'll see that the difficulty with the approach of the minority is that the owners were never intending to sell the charter as an asset. So although the minority said, why are you looking forward into the future as to whether there is a war? You should be just saying, well, at the time, no one thought there was going to be much of a war, and so let's just do a difference in value between the charter you had and the charter you could have got in replacement. Whereas the majority said, well, that might work if you're intending to sell something, but it's a charter, you're going to run the charter. And therefore, what would have happened, and of course in the golden victory the answer is, you would have run the charter for a few years and then war would have broken out and you would have been terminated under the clause that permits termination. So we say a charter's a pretty good example of a business that's run for income. And we'll see in the new flamenco that, which hopefully will be our almost last case, and is at tab 7. It was 5 years before Stanford, but I don't think that makes any difference. The facts of... It's a pleasingly short judgment. The facts are quite simple. Charter party, the charter is redelivered 2 years early. There was no comparable replacement charter available. And the market was high, so the ship owner claimant sold the vessel for $23.7 million. But for the breach, the ship owner would have received charter for 2 years, i.e. the charter would have run to the end of its course, by which point the capital value of the vessel would have been only $7 million. So the defendants cried foul in this claim, which was for lost charter for 2 years, saying, what are you talking about? you made a huge profit, we did you a favour by selling the vessel, and there wasn't even a replacement charter available of a similar sort. By selling the vessel, you made a massive profit. Look at the capital value you made, and it's an actual profit here. And if we go forward in the reasoning to page 176, paragraph 29, there's a lot of analysis of the decisions below, which didn't go the same way. And then if we look at paragraph 29, the second sentence, Lord Clerk, on the facts here, the fall in value of the vessel was, in my opinion, irrelevant because the owner's interest had nothing to do with the interest injured. This was not because of some strict rule, because the Court of Appeal suggested perhaps it was to do with the benefit having to be of the same kind, and Lord Clerk eschews that. He says a difference in kind is too vague, difference in kind between capital and rental income. The essential question is whether there's a sufficiently close link between the two, i.e. between the sale and the benefit that's lost. Sorry, the losses. The benefit to be brought into account must have been caused by the breach or by a successful act of mitigation. Now, plainly in this case it was caused in fact because the charterers, the ship owner sold early, I think forced to think about doing so by the fact that they were stuck with a vessel they couldn't charter. Doesn't mean they couldn't have done it at another time, but in fact that's what led to it. But if you look at paragraph 32, there was nothing, third line, nothing about the premature termination which made it necessary to sell. It could have been sold earlier, during the term of the charter party. If they decide to sell, they're making a commercial decision at their own risk about the disposal of an interest in the vessel, which was no part of the subject matter of the charter party and had nothing to do with the charterers. Now, you might say, well, our case is a bit different because the counterparty here is an advisor, the defendant, rather than a charterer who is renting. So our case is not a breach by a tenant, it's a breach by the advisors. But we say, nevertheless, the factual position that the property was going to be rented as not too remote within the scope of the defendant shows that a commercial decision to sell would be no part of the matter of this defendant. It wasn't taken, of course.
Think out round whether this has much to do with it at all.
Yeah.
I mean, what Lord Clerk is saying is the sale wasn't affected by what happened on the charter party. They could sell anyway.
Yeah.
So they're just unconnected. Now, why does that help us here?
In our case, the development could have been sold in 2016. Barrowfen came out of administration and out of D1's control. Waitrose had pulled out, but they could have sold the development. In 2017, they learned everything that had gone on and could have sold then. They got planning permission in 2018. They could have sold then. Of course, people sell with planning permission all the time. That adds value. They could have sold in 2021, which is apparently the date when we're deeming a sale. Of course they could. But they didn't consider doing so. There's no evidence that they valued it. We now know from experts valuing net present values that the costs of finance were this, and you can compare the two developments in this way. But it was never suggested that you should have got out of the business at that time, that you knew what the numbers were. They weren't valuing the business. The facts are they didn't value the business in 21 because they were just going to rent it out. There's no need to.
But I thought the magic of the date of 2021 wasn't the date on which they could have sold. The magic of 2021 is the development was finally concluded. And what you're doing is saying, right, you've built the thing now, what's it worth to you?
Well, you had the thing for 30 years.
You had a different thing. You had the thing without the development.
Yes, and then you had the thing with the planning, and then you had the thing with some development.
Yeah.
The defendants' breaches were long before. They weren't breaches about how the development was run. So you could say that once you've got your replacement planning permission, the defendants are out of the picture. Their causative impact is gone. So why the point of completion of the development? That's nothing to do with what the defendant has to do, and it's an arbitrary date, because you can sell at any time. There's no consideration of sale at that time. No one put to the witness, Mr. Patel, well, you should have extricated your £12 million of developer's profit. Firstly, no one put that he knew that was the developer's profit, because there was no valuation. And you should have taken out your £5 million of equity. And that would have been a reasonable thing to do. And what would you have put it in instead? That would have been more profitable or less profitable or attractive or not. It was never explored at the time, and it was never explored in cross-examination, because no case was made that this date was salient on the facts. So yes, the development was completed, but this isn't a builder being sued who finally we got the development done. It's an advisor on the sidelines, and that cuts both ways. So why that date? Why not 2023? There is no reason, and no reasons are given by the judge, other than it feels like a sort of a key date when something's cleaned off. But why then, when this isn't a builder who's supposed to complete the development? We're trying to get an income stream. The reasonable act of mitigation achieves the income stream, and then you should be able to enjoy the income stream. That is the mitigation in fact, in order to achieve the thing that you were initially hoping for and that you've been awarded damages for in relation to the 5 years.
Can I just be clear?
Yes.
Sorry, I'm sorry for being stupid, but is the logic of your argument, that no developer's profit should have been taken into account at all, such that even if the finance costs were of a much lower order of magnitude, i.e. that, because we've seen on the facts, I think you say that when you take the finance costs into account, they eliminate the developer's profit. Correct?
Correct.
Is it right? You'd say even if they had been much smaller and would not have eliminated the developer's profit, it's just the whole developer's profit was just something the judge just shouldn't have got into at all. He just shouldn't have credited. I mean, I'm just looking at your notice of appeal.
Yes.
Your notice of appeal is sort of ambiguous in that respect.
He shouldn't have gone into the profit is notional. If he wants to go into what would have happened, we could have claimed this because we now know it's a positive value, but we didn't want to spend all the money on experts. If he wanted to go into what would have happened, he should have said, what is your future rental income? What's the future profits of your business? Are they up or are they down?
But I think what you're saying,
yes.
I thought what I understand you to be saying is that compensation, yes, for the delay in receiving for the rentals that you would have received if the property had been developed. But the fact that it's a better and more valuable property than the original one you had planned actually was neither here nor there. The judge just shouldn't have gone down this line of inquiry at all. In other words, it's just irrelevant that it's a more valuable property, that there's a developer's profit as calculated.
Yes.
The whole thing was just completely wrong.
No. The whole thing was completely wrong if you're talking about valuable and developer's profit. But as we've explored, what he should have done if he wanted to do this exercise is talk about, was it more profitable? To do that, as we've seen, the numbers are broadly the same because it's just the net present value of the future income stream. So the credit is not of itself objectionable, providing you take into account the net present value of the finance costs. So valuable is nothing to the point. Profitable, coal costs, charter party income, the Thai Airways leasing, the profits going forward are what you measure, and if that's up, well, you've got to give credit for that. That's pecuniary advantage that you're going to get in the future. And it just so happens here that there's a negative number, which is why we're arguing this way. And this...
So
yes.
Capital value on your case of itself is irrelevant.
Yes.
insofar as the word capital might come into anything, it's only in the sense that you might capitalise
Capitalisation.
future income and cost
Yes.
figures to arrive at your.
We only do that
present
because we're having a trial now, and we can't wait 20 years and see what the numbers are, and that's just what we do.
values. Yes, I see.
And we shouldn't be tricked by that. So if you look at paragraph 33 of Flamenco, the first half says, this is why they could not have claimed the difference in market value if it had risen between the time of sale. So let's say the market's up, they sell the vessel, and then 2 years later, the vessel would have actually been worth more. They can't claim for that either. It cuts both ways. It's a point I've made already, and it's a point I make here too. If the boot had been on the other foot, we'd sold the whole development and the land, and had crystallised a loss, because rather than it being 2.5 million developers' profit greater, it had been developers' profit down on the AOS, the older scheme. So the new scheme, it turns out, even in a capital basis, is worth less. We get less money on the market. Can we claim that? No, because equally that's just our commercial decision to sell, and the defendants are entitled to say, as Mr. Stewart would be vehemently saying today, this was a business where they were claiming rental income. They actually got awarded rental income. Going forward, they were only going to get rental income. They chose to sell. They cashed in like Flamenco. But you can't do that, because your loss is your income stream. You mitigated the lost income stream by replacing it with a new one, and you've got to run that forward into the future. Let's look at the profits, he'd be saying. And he'd be right. So, my lord, that's what we say about that. And the way you have to, if you can't, therefore, a could is not enough if you're asking about something like this, which is selling a business. And there's no case that we've been pointed to that says, just because you could have sold your business, that's enough. And if we just
thinking,
Yes.
I'm not sure I've
Yes.
quite worked out how New Flamenco would map onto our case. But
Yes.
could was enough to make the sale irrelevant. In that case, wasn't it? I mean,
Could.
Lord Clark says, well, you could have sold the vessel anyway, and that's good enough to make the profit that was
No.
gained
So
irrelevant.
what he's demonstrating there is that you can sell at any time. He's demonstrating the lack of it's one example of the lack of a connection. But his point is you just have to keep drawing charter. And in fact, what they said is you should have gone out and got the best charter you could, which is some spot charters. You would have suffered a big charter loss. And they therefore awarded substantial damages here, even though in bank balance, the claimants were well up because of the sale, because they said we have to disregard the sale. We have to assume...
So why did they have to disregard the sale? Because
Because
it could have
they've
been
sold
done
their
anyway.
business, and that's nothing to do with the defendants. They took a speculative risk to cash in the business, which is exactly what's said that we should be deemed to have done. So that's why, my lord, it's the stronger but opposite version of our case. Just a final case, just briefly, and this isn't in your bundle, you'll have seen it before. It's Esso and Marden. It's only 1 point on the case. We'll just hand them up. My learned friend knows that I was going to go to this. It's only an illustration, my lord. It's a case where some misstatements induced purchase of a business. And you don't really need to know any more about the facts than that. And if you go to (829), you'll see how Lord Justice Ormerod deals with the question of the date of when the business should be valued. The business ultimately just ran into the ground because it was much worse than was stated. And you see at 829 from the first new paragraph, which is how much, an explanation that you see a bit further down. By September 1964, the breach of contract was clear to all concerned. The question was what could be done about it. He should mitigate his loss. He might have surrendered his tenancy. So by that date, he's realised the business is a dud because of the misstatements. But he didn't surrender his tenancy and cease to trade. And the other side wanted him to keep the business going. And he attempted to carry on with the business. This is next to the letter D. He said he was trapped by his losses. The trading position failed to improve. And in the end, the business finished, I think, in 67. And he was able to recover all of those losses. Now, that is not our case, of course. But what happened there is the court conducted a factual, sensitive exercise to see what was the reasonable thing to do with your business. Because it's not just a piece of property, it's a business. Should you have sold it once you realised it was a dud or not? And it depends on the facts, and you examine the witness and you talk about the decision. Could he have sold it? Yes. He could have surrendered the tenancy. It said he could there, but he didn't. And so the question is, did he fail to mitigate and or break the chain?
And because it's about failure to mitigate, it's a different subject, isn't it?
Well, it's about failure to mitigate, but it's really about speculation as well, because that argument can be made. Well, you speculated. It actually says that he took the risk. He wanted to try and make the business work. Because he could have sold, he obviously speculated. But that wasn't a...
When you use the word speculated to a non-contract lawyer
Yes.
who does judicial review day in, day out, what do you mean by speculation?
So it was
means different things. to
Yeah,
different people.
sorry, my lord. I could have gone into Stamford a bit more, but the explanation for the market measure rule in goods cases is that at the point at which you have an available market to replace your goods or replace your buyer, if you choose not to do so, and some businesses might reasonably do so, they'll take a view that the market's going to go up.
Yeah.
But if you choose to do so, that breaks the chain of causation because you're
Yeah,
speculating.
but that's not the problem.
Yes.
Is they use the word speculation.
Yes.
Because in order, I speculate when I put 50 quid on the hope for victory
But
in the
it's
10:30
yes.
Doncaster.
So that's the point. It has to be in order, and in order for my learned friend to be right, retaining the business after the development was completed has to be treated, because it wasn't actually sold, so there were no actual crystallization, has to be treated as breaking the chain of causation because it's speculating, by which I mean taking a commercial risk. And I say that's obviously right, where you have an available market to sell some fungible
The
goods.
speculation is a word to describe the choice somebody makes as to whether or not to realise a business.
It's the choice whether or not to enter the market at a particular time. Or it could be other commercial risks, but that's the typical one. And if you're taking
the decision to sell or not.
And if you're taking a commercial risk, then although it might be reasonable in a commercial sense, it's not to be for the account of the defendant. And if you succeed in your speculation and actually make a lot of money, you don't have to bring that into account. See you flamenco. And if you lose and actually the market goes the other way, you equally can't increase your losses.
With the greatest respect, you're telling me what happens when you speculate. And my question is a different question, is what are you doing when you speculate? And I think you've answered the question, which is, it is the decision to sell or not sell, or the decision to enter the relevant market or not enter the
Well, no, my lord, it depends on the case. That's what it is in a case where you're trading fungible goods. It's an evaluative decision for the court that in a particular commercial context, a step taken is a speculation or not.
Yeah, well, what is a speculation? You're using it as if it's like an ornament or a beach or a table. I can point at it. That's a table. It's got 4 legs and I put things on it. What is speculation? When you use, not what the consequences of speculation is or isn't. What is it is what I'm wondering in this magical commercial world.
My lord, I agree. We say this. If you continue your business, that can't be a speculation.
No, that's telling me what happens. I'm asking you a different question.
Well, it's a circular definition.
Speculation is just the label which has been placed upon this. I mean, it's the label that the courts have placed on it, so that if, as I understand it, if I have a pen or something which is completely fungible, let's say, or widget, and I contract to sell it to you and you default on the contract, then generally speaking, my damages will be the difference between the market price at the date of your default and the contract price. But and that's on the hypothesis that when you default, I'll sell it to the next willing buyer of the widget. And I just have lost the money on the more profitable contract with you. If, however, I decide not to sell and keep it, and in fact the market goes up because I am, quote, speculating about whether the market will go up or go down, then I might be able to make a profit and I can keep it. It doesn't reduce the value of the damages I claim from you. That's how
so
I
it is a
understand
commercial decision to sell or not sell or whatever.
Yeah, it's a commercial decision.
Yeah.
It's a commercial decision.
But the word speculation just appears in some authority somewhere, does it?
That's right. I think it was Lord Toulson and earlier Lord Justice Toulson, or Toulson J. He then cited himself and it became the rule, I think. My Lord.
But anyway, I'm happy now. It means a commercial decision.
Well, but it's evaluative because it's a commercial decision to take on a revised development scheme, but that's held to be a reasonable and sensible thing to do in the circumstances that doesn't break the chain of causation. So I'm afraid that whether something breaks the chain of causation, as Lord Hoffman would have us say, is a common sense thing, which means one can't really define it. It just depends in the context of the cause of action and the circumstances, whether it's treated as absolving the defendant of the consequences.
That's why I don't think learning a new word, speculation, helps me at all.
It was supposed
all
to be
I've got to do is
right.
look at what's happened and see whether or not the chain of causation is broken. That's what I think you're asking me to do.
Absolutely.
The speculation doesn't help. It sounds terribly glamorous, but it's frankly irrelevant.
Well, glamour is
it's
not...
whether the act in question is broken,
Yes,
the chain of causation.
I'm not normally accused of glamour. My Lord, that's right. So, to cut it short, or to cut it long, because we have gone quite a long time, I think I should wrap up. We say that on the facts and on the law, a decision not to sell your business and cash it in will very rarely, there could be facts, but they weren't explored here, very rarely be such a break in the chain. And indeed will often, if you do sell, it often will be a break in the chain. And that there's no cases to the contrary. And the fact that you could sell is a complete red herring because it doesn't get you far enough to break the chain of causation, because you could sell earlier and you could sell later, and any business can sell. So the question is really, what's the business that you're talking about? But also, is there an intention to sell? And if not, would all reasonable buyers be expected to sell, at least if they're not taking a commercial risk? And we would, claimants. And we would say, and so reasonable does come into it in that sense, because in my Lord Justice Snowden's example, the buyer who decides to wait and see, chance their arm on the market, is acting unreasonably in the sense that all reasonable buyers not taking a risk would just sell. He's not unreasonable in that he may have good views about the market and be clever. So it is reasonable, it is about mitigation. They're two sides of the same coin. Something breaks the chain of causation if it's non-mitigatory, and if it doesn't, well, it must be a caused act of mitigation consequent in a legal sense upon the breach. And we say that just the fact that this is development of a property that has a capital value, and that it happened to have been the whole land rather than a bit of it, makes no difference because it was in the rental business. And that's the core of the point. And the cases that we looked at, we say, are indistinguishable because they rightly say, well, it depends on whether you did sell or intended to sell, or else really should have sold because otherwise you're taking commercial risk. Continuing what you did, at no point during the scheme was taking such a risk. It was just continuing the business. It's ipso facto reasonable and contemplated to conduct a development scheme and take rental income, because we know that it was found reasonable to continue the development, and we know it was found in the contemplation to draw rent from 2016 to 21. So we say in this test of break of chain, the judge in his 2 paragraphs, having not yet had any evidence about finance, and there being no evidence about cross-examining about reasonable in the particular circumstances, made an error of law in finding that merely, and this was his only reasoning, merely because the claimant could have sold then, and without considering whether the claimant could have sold at other points, which of course they could, that was a break in the chain. And that's what we say, my lord. And I've obviously borrowed some of my time from tomorrow, but I think that will probably prove to be fine, but we'll see. So I'm going to sit down now and let Mr. Stewart have something to say.
Thank you very much. Mr. Stewart.
My lords, my intended order as follows. I'm going to just briefly deal with speculation because it's the top of everyone's court and there's a typically lucid explanation of what is meant, which is exactly what my Lord Justice Lewis thinks it means, but I will show you where Lord Dawson says that in Bunju. I'm going to deal with what are in effect the 3 relevant appeals in this way. I'm going to respond to my learned friend's appeal. I'm then going to open my appeal in relation to Hartle and Lacey, having, as it were, tramped over the ground in terms of the credit, and explain why it is that we say that the judge was wrong in relation to that. There are 2 points about interest which my learned friend, Mr. Fulcard, is going to deal with. The first point, which arises in any event, is where we say, in essence, that the judge awarded interest twice on capital sums before the 21st of June of 2022. That amounts to an error of approximately £167,000. The second point is that, which only applies in the event that the first appeal is not successful, is in failing to take into account the credit which we've been talking about. Mr. Fulcard will explain those points, and he'll do so afterwards. And then that will be what we say, and we'll then hear further from our learned friends. Can I just deal first of all with the speculation point? It's mostly clearly set out in the Bungi Nagira case, which we've got at tab 4. I'm not sure why we've got the All England reports, but we do seem to have the All England reports for this, for which apologies. What that case was actually about was the application of some particular GAFTA terms and whether they did or did not modify the ordinary rules applicable to the assessment of damages. And I don't propose to go to the facts of them. But if your lordships would be kind enough to go to page 85 of the bundle, 1106 of the reports. You'll see that starting at paragraph 78, he's explaining the principles which apply in relation to unperformed obligations. And then in paragraph 79 is the measure of loss which may fairly and reasonably be considered as arising naturally, according to the natural ordinary course of things from the breach, Hadley and Baxendale. And it's fair and reasonable because it reflects the wrong for which the guilty party has been responsible and the resulting financial disadvantage to the innocent party. The guilty party has been responsible for depriving the innocent party of the benefit of the performance under the original contract. And then the availability of a substitute market enables a market valuation to be made of what the innocent party has lost and a line thereby to be drawn under the transaction. Whether the innocent party thereafter in fact enters into a substitute contract is a separate matter. He has in effect a second choice whether to enter the market, similar to the choice which first existed at the time of the original contract, but at the new rate prevailing, the difference between the basis being the normal measure of damage. The option to re-enter or stay out of the market arises from the breach, but it doesn't follow there is a causal connection between the breach and his decision whether to re-enter or stay out of the market, so as to make the guilty party responsible for the decision. The guilty party is not liable to the innocent party for the adverse effect of market changes after the innocent party has had a free choice whether to re-enter the market, nor is the innocent party required to give credit to the guilty party for any subsequent market movement in favour of the innocent party. The speculation which way the market will go is the speculation of the claim. So it's exactly what you were saying, my lord. What the meant is, in this context, it's not speculation in terms of some sort of far-fetched or putting the money on the new market. It's a decision. And I should emphasise, and this will become quite important, two people may both perfectly reasonably decide to keep an asset and sell it. And they may be two otherwise completely indistinguishable people. And all that divides them is the different views to the market which takes place. And indeed, that is, on one view, what happens every day in any market, whether you're buying and selling cows, shares, houses, or whatever it is. Some people will think that the price at which something is being offered is too high and aren't prepared to pay it. Others people will do the difference. And one of the major criticisms that we have of the way, the typically lucid and attractive way that my learned friend puts his submissions, is that he effectively seeks to put up a whole series of straw men. He says, oh, we've got to show that something's unreasonable. We don't have to show that something's unreasonable. It may very well be that Barrowfen, indeed, I put no case to the contrary, as he repeatedly said, acted perfectly reasonably in deciding to keep the property in tutu. Equally well, another entirely reasonable person in precisely the same position as Barrowfen may have come to the opposite conclusion. But the effect of my learned friend's submissions is that one of them has to give credit for £2.45 million and the other one doesn't. And those two people, otherwise being entirely the same, and it's only because what is the difference between their attitudes. And that's one of the points which in due course I shall criticise. Now, can I...
I mean, this explanation, which I think is the one that I sort of rehearsed rather less elegantly with Mr. Kramer, is this particular explanation is predicated on the availability of the market, and it's in a breach of contract case between buyer and seller.
This one is, yes.
Yes, and indeed, the whole availability of a substitute market is the predicate for this approach, which is not what we have here.
Well, my Lord, I will respectfully seek to disagree, actually, in relation to that. What I say, in a nutshell, I'm going to come to this very early in my submissions now, so I might as well make it, is that the way that my learned friend now seeks to put the case is fundamentally contradictory to the way that the claim for damages was run at trial. And it's actually contradicted by the acceptance, at least at some points of my learned friend's submissions, that the decision to do the revised development scheme was part of the causal consequences of our negligence. And he needs to make that, although it was disputed vigorously below, because obviously otherwise he doesn't get 55 months rental at all. I'll show you the figures in a minute, but he gets, in fact, vastly less than he does now. The logic, and we say the logic which on this point this court ought to support, of the approach of the judge is this. We were acting as solicitors for the company. The company owned a development site in Tooting, as you know. The original controlling shareholder of that, Girish Patel, was extremely keen to develop that site and obtained the original planning consent for it, and indeed the amended original consent. Rather ironically, the two shareholders who now control the company were against the development of the site. And you will have seen that I sought to persuade his lordship that led to certain findings in which I was not successful. What the effect of what the judge found was that as a result of the disputes between Girish Patel and his brothers, the brothers hadn't appreciated just how valuable this site was, and if they'd been on board and understood it, they would have in fact have developed it. And that therefore meant that on the judge's findings, the fact that the brothers, two of the brothers, who were entitled, as the judge found, to control of the company, were kept out of controlling the company for a 2-year period from September 2014, which was the time the judge found that had we not been negligent, they would have obtained control of the company, until September 2016, which was the point at which they did obtain control of the company. They actually became controlling shareholders in December of 2015, but they weren't able to control the assets of the company because of the administration until September of 2016.
Sorry, and those dates, give me those dates again, or just give me the reference as to where that finding in the judgment is.
Yes, certainly. The findings in relation to the dates are, if you see paragraphs 621 and 622, you'll see in the judge's judgment tab 18, and it's in the second of your lordship's bundle 457. I'm grateful. You'll see that that doesn't deal with the September 2014 date, that's earlier, but you'll see that I found there's a real substantial chance Prash and Shurish would take control. Yes, it does. It's paragraph 621, by the end of September, that's September 2014, and proceeded with the original, amended original development scheme by January 2015. So that's the critical finding in relation to what I've just said to your lordship. Now, they actually get control in the sense of the company coming out of administration in September 2016. And so at that point, there is a 24-month delay in consequential upon our negligence. And that's the biggest delay there can be. The alternative period of delay is arising from the administration claims, where the company goes into administration in December of 2015, comes out of administration in September of 2016. So there is a 9-month delay for the administration claims. So the maximum delay is 24 months. Now, just pausing there, the award which is therefore being made, and which you are considering in this case, is what damages, at a maximum, if I can put it this way, to award Barrowfen for not being under the control of its proper shareholders from September 2014 to September of 2016. And the judge found, there's obviously no dispute about that, but for the negligence, Prashant and Suresh would have wanted to go ahead with the amended original development scheme. And he finds that, as he has to, on the balance of probabilities. He then considers the submissions that I made as to why it was that, having made that finding, actually that wouldn't have occurred. And I went through a whole series of things, and they're in the judgment, but they include that Mr. Girish Patel wouldn't have gone along lightly, if I can put it that way. Mr. Girish Patel was quite prepared to forge documents. Actually, so were his brothers prepared to forge documents, but there we are. You can see that from Appendix 2 to the judgment. And that in those circumstances, us telling him to get independent advice wasn't likely to have led to him saying, you know, you're absolutely right, I'm going to go and see some other solicitors. Now, we sought and were refused permission to appeal in relation to that, so I'm just, this is a pretty unusual case. But the judge finds that there is a 60% chance, given the evidence which he accepts from Prashant and Suresh, that the original amended development scheme would have gone ahead. It would have started by January 2015 and it would have finished by September 2016. So just pausing there, that is a 21-month period for the construction. So he effectively says there would have been 3 months for them to get control of the company, understand what was going on, submit an outstanding Section 106 agreement, and get actually a minor variation.
I think I've written down the wrong date because it didn't make sense what I've just written down. Could you just give me those dates again?
It would have been a 3-month period from September 2014, when they get control of the company, to January 2015 to sort out some wrinkles on the planning permission. They don't matter for present purposes.
Oh, I see. Sorry, it is correct. Yeah, okay, got you. Yeah.
And then there would have been a 21-month period from January 2015 to September 2016, during which the development would have actually taken place. That's how the 2 years is made up. Now, what he then finds, and we'll look at the pleading of my learned friends in a minute, is that he awards them damages not on the basis of the 24-month period through until September of 2016, or a delay thereafter, but for a 55-month period through until March of 2021. And just pausing there, what that means is that there is 31 months at £89,000 a month for which we are liable by way of the lost rental position. And the logic of that is this. This was a development site. It wasn't completely empty, but it was almost completely empty. It had been cleared by Girish. It was there to be developed. Now, you could have claimed damages, for example, on the basis of the rates and the utility bills during that period. You could have claimed damages possibly on the basis of a lost opportunity to sell, but he didn't do any of that. They claimed it on the basis that they were entitled to the actual losses during that period. And just to be clear, they were not forced to put forward the amended original development scheme. They could have sold the scheme, they could have proceeded with the original planning consent, they could have tweaked it, they could have done all sorts of other bits and pieces. But they, and it's right to say, we accepted perfectly reasonably that they were reasonable in going ahead. And my learned friend expressly accepted this afternoon, as he must, that that is what my Lord Justice Newey referred to as mitigation in fact. And the judge, and at this point it may be helpful to look at the pleadings. If you go to the pleadings in Call Bundle 2, my learned friend took you there this morning, and go to the re-amended particulars of claim at tab 24. Just while we're on it, at C620, you've got the history of the re-amendments. The amendments were introduced in July of 2020. The re-amendments were September of 2020. And if you go through to the losses suffered by Barrowfen, which one sees at C672, and my learned friend took you to. The first head of loss, which is claimed, is 54 months of delay caused by the delay to the development of the Tooting property. And just pausing there, if you look just above that, you'll see that in paragraph 114, you see their case on causation. They had a case which the judge didn't fully accept of taking control in early 2014. The reason I say that he didn't fully accept that is that he finds that it would have been September 2014. They'd have discovered the full details about the proposed development of the Tooting property, would have progressed it as quickly as possible, such that construction would have commenced on about the 1st of January, completed by 2016. Instead, as explained in paragraph 106, the development now will be completed. And you see there June of 2020 in the original particulars, December of 2020 crossed out, and in the end, the case proceeded on the basis of a completion date of March of 2021, which was the time essentially at which the trial took place. Your lordships may recall a pandemic which swept around the world, and that certainly had some influence in relation to those dates going out. Obviously, June of 2020 is 3 months after the original pandemic, and the trial itself took place in March 2021. It was entirely remote because it was during the second period of lockdown, which was all taking place. But what that means, therefore, is this. The effect of the judge's award on the lost rent was that we were effectively the insurers of the actual period of the delay which took place. In other words, we were found responsible at law for the entire period. And that was the basis upon which this was argued. In other words, my learned friends were saying, because they had to, you are factually and legally liable for the consequences of the actual development taking place. And they also had to say they acted reasonably. My learned friend says we didn't challenge that. We didn't, but that's a necessary corollary of how they put their case. Then over the page, my learned friend has spent an awful lot of time telling your lordships how it is that there's a great difference between capital loss and so forth. Introduced by amendment in July of 2020, crossed out in September of 2020, is this claim. Lost developers' profit under the revised development scheme compared to the original development scheme, taking account of the increased cost to 24.2 million compared to 14.7, the increased financing costs, but also the increased rental income, particulars to be provided following exchange of expert reports. Now, that gets crossed out, and it's not supported by my learned friend's expert reports when it comes in, unsurprisingly, because as we know, if you look at that, it doesn't produce a loss at all, it produces a credit. Now, my learned friend says, we introduced our amendment late, and the judge...
Sorry, wait a minute. You say that that would have produced a profit. I thought the developer's profit taking into account of costs and increased financing costs. Oh no, sorry, the financing costs, sorry, that's not. Yes, that is.
Can I knock that one on the head? Sorry, my lord. I mean, I've assumed I know what the question is going to be.
Yeah, no, go on. It was because you said, of course, it was deleted because, of course, it would have been...
Yeah. Well, we don't know why it was deleted. It was deleted. I mean, we're not privy to the... but it was deleted. But the fact is, this uses the term developer's profit. Developer's profit is referring to the development. And the unchallenged facts on this appeal are that as at March 2021, the developer's profit produced 2.5 million in round terms, more than the developer's profit on the original scheme. And just to be absolutely clear, I can show you this if necessary, that takes into account all of the financing costs up to and including March of 2021. It takes into account the increased construction costs, it takes into account the money that you're going to borrow, and so forth. The figures which my learned friend has been looking at is upon the assumption that you are trapped into this development for 25 years. Then he accepted some figures which had been put forward by the valuer, which showed that actually taking into account the actual costs incurred by this actual company, which were a mixture of equity provided at particular rates from essentially other family businesses, and loans which have been taken out on commercial terms, taking into account those actual costs, then you get to the minus 900,000 figure. Now, with the greatest respect, that is an entirely artificial exercise, because as the judge says, what you're looking at there is you're comparing a position where Barrowfen assumes that its costs remain unchanged going forward into the future. It assumes that you're trapped in when you're not trapped in, and it assumes, obviously, that you're not going to do anything else about those costs going forward.
Those are the questions, but as I understand it, the debate is not about the financing costs up until 2021 when the
Agreed.
project was completed. This is you saying, well, we want to have credit for the 2.5 million developers' profits. They say, yes, but that is all arrived at by effectively capitalising the future rental stream, because that's how value is arrived at.
Well,
Subject to your point about selling some flats or whatever. And they say, well, in which case, if you're asking for, your side is asking for credit for that increased value, you should take into account the fact that over the period of the rental stream which gives rise to that value, they're also going to be paying financing costs over that increased rental stream. So they say you can't have one without the other.
Yeah, well, that's how it's put. It's wrong. What you actually got, the exercise which the judge actually did, and which the valuers actually did at March 2021 is this. And I think at this point I agree with my learned friend. The valuers sought to mimic the market. In other words, they sought to provide an assessment as to what this property in Tooting was worth, developed in March of 2021. Now, mimicking the market by way of valuation techniques involves, and I think this was a point that your lordship put to my learned friend, trying to assess who's going to buy this property. Now, as I shall show you, because I think it is quite important, the property which was actually available to Barrowfen as at March of 2021 was actually quite an attractive property from the point of view. It got an element, sorry, I've forgotten the word for it, the subsidised housing, the affordable housing, which had to be sold because that was a condition of the planning consent, and that was valued, unsurprisingly, at the figure which you're going to have to sell it for, and in due course it was sold. It had 17 odd million, the valuers were different, of the total value, as being flats. Those flats could be sold on a long leasehold basis for capital, or they could be rented out for income, or they could no doubt be disposed of on a mixture of the two, or on intermediate terms with premiums and so forth. In other words, you could do whatever you wanted as the purchaser with the flats. You also had a hotel, where it is common ground that that was valued on the basis of an income stream, and you had some retail property, which was valued on the basis of a retail stream. And the value...
Not on the assumption that Barrowfen was going to run the hotel, but on the assumption that...
No, assume,
it would be let out.
Or there'd be an operator.
Yeah, quite. So you would lease to an operator.
Yes.
Or have some kind of arrangement with an operator.
I don't think anyone's expecting Barrowfen to run the hotel this way, but there would be an arrangement whereby income would be produced.
Yep.
Now, those, in valuation terms, it's whichever purchaser is in the market from amongst the people as around there who's most likely to pay the highest price, which gives you your value. For some things, and I'm sure your lordships will be familiar with this, retail, almost always commercial and so forth, mimicking the market involves making an assessment of rent, then making an assessment of yield. The yield in broad terms takes into account all sorts of things, most obviously the difference between the likely future increases of rent and the costs of obtaining money. And there are, therefore, within the valuation, elements which try and forecast what people are assuming they're going to be able to obtain funds for, either by way of equity or capital. So to that extent, it's within there, but it's a market mimicking process.
The finance costs are built in. The finance costs are built into the valuation in the sense that,
Yes.
the price that somebody will pay.
Yes, I mean
takes into account their own cost of borrowing.
Yes.
To buy the rental stream.
Or the money they could use elsewhere. If you're looking at a residential property, there will be some people who need a mortgage and others who don't, but they will both presumably take account of the possibility that they could use their funds elsewhere and so forth. And so yes, you mimic the market, and that is to that extent built in, but it's no more than that. But the essential point is that produces your market price.
Yeah, I mean, is it asking too much to ask whether this was ever encapsulated in any sort of form of agreed summary between the experts, or is it in the judgment or not?
I'll show you, if I may, the valuations. The way that the judge dealt with it there was a surprising measure of agreement between I say surprising. There was a substantial measure of agreement between the valuers. The judge dealt with the areas of difference, but I will show you the reports, which are relatively short, and you can see, as it were, from those that what I'm saying is correct, if I could put it that way. Yes, it is too much to suppose that there's a nice, neatly written, handwritten, or not handwritten, but a typed version of what it is that I'm saying. But coming back, therefore, to the logic of what the judge did, and I'll deal with the legal consequences. My learned friend says, well, we could have sold the site without planning consent. Or we could have sold it with planning consent, the original consent. We could have sold it with the amended original planning consent. We could have sold it, no doubt, partway through the development. All of that is absolutely true, but the whole of his case was based upon the fact that we wanted to go ahead with this development and get to the stage where we got a completed development. And the judge doesn't articulate this precisely, but it is, if I may say so, self-evidently the case. One can see that this property was originally bought for a little over £1 million in the 1980s. One can see from the valuations which are being put forward that the value of the cleared site, one's got a reference to the site being worth something like £3 million at one point, is enormously enhanced by the carrying out of the development. And in particular, the idea that you would sell a development once you had started to develop it partway through is completely unrealistic. I mean, that really is the way where you are going to achieve less than your maximum value, because any purchaser, all the sort of risks of the building contract and so forth are going to be there. So the logic of the judge's position, which he accepted at the invitation of my learned friends, I say my learned friends, Mr. Kramer, of course, didn't have the benefit of being there and has the advantage of coming in at this matter afresh. But the logic of the position being taken was we're entitled to be put into the position that we would have been in with a completed development, and we want to compare the position that we would have been in September 2016 with a completed development and the position in March 2021 with a completed development. And when my learned friend said, what's the logic of March 2021? The answer is that's when their claim for a loss of rent comes to an end. And that must also be on the logic of his position when the causal nexus between my client's negligence and his client's loss comes to an end. If we can then just come back, I've made the point that they introduced and then crossed out a claim for lost developer's profit. And then we get little b.
And sorry, and you say that the nexus, as you put it, between your client's negligence and the claim stops in March 2021, because that's when they have a completed development and
They can do what they want with it.
yeah, because you're liable for the delay.
Yes. Yes, we're liable for the delayed development. That's the crucial point. They've measured the delay not by reference to their control of the company, 24 months, which incidentally would produce 24 times 89,000, rather a lot less than what is being claimed here, but by 55 times 89,000 in broad terms. Then if we can, just coming back to the C673, they also claim B, and this was awarded in full, this isn't subject to any discount for loss of a chance, legal and other professional costs spent on amended planning applications, building designs, negotiations with tenants and contractors since September 2016 because of the delay to the development, estimated at, and then the final figure is £339,992.67.
Just so I've fully understood where you're going with this, I hope. You say in March 2021 the claims for delayed rents ceased.
Yes.
Because thereafter, if, for example, the company had decided to hold it but to grant rent holidays to tenants or not to rent it or do whatever else it wanted with it, keep it but just do it something different with it, that's no part of your breach, the result of your breach, because your breach is causing the delay.
Yes, it's right. To use the term Lord Toulson says, it's speculation on their own account. They're fully entitled to do what they want with this property.
Yes, it's not. I want. Okay. My lord, I want to get away from the
all right.
Speculation.
They are free to do what they want with the property.
They have a free choice as to what to do with the property, which I think is the better way of putting it.
Yes, they've got a free choice of whatever they want to do, unencumbered by what we have done wrong beforehand, and they've received compensation to the tune of 55 months worth of rent, subject to the 60%, but I mean not in subject to that point. And they've now got a completed development, but they've got it in March 2021, whereas the judge's findings had it in September of 2016.
So your wrong was in delaying the completion of the development.
Yes.
And your wrong came to an end when they had a completed development.
Precisely, my lord.
And what they did with it afterwards is up to them.
Absolutely.
That's
Just absolutely. That's it. That's it. And my lord, just to highlight B, these legal and other professional costs, as is apparent from the judgment and the findings, and indeed the evidence, those are the costs of making the alternative amended scheme and the negotiation and so forth. And so they are claiming, as against us, the costs which they actually incurred for this sum. And as the judge says, we'll see this when the judge, he says that Ms. Hilliard couldn't have it both ways in relation to this. You couldn't claim for the costs which have been incurred in relation to this, whilst seeking to challenge the legal nexus. Now, my learned friend, Mr. Kramer, seeks to follow a very narrow and very difficult course, because unlike Miss Hilliard below, he accepts that the entry into the revised development scheme is within the legal consequences of our negligence. And he has to do that because otherwise he's going to get chopped off at the knees in relation, for a start, to 31 months loss of rent. And even if he were otherwise to succeed on the appeal, that would be a Pyrrhic victory. Presumably he would also get cut off at the knees in relation to the 339,000. So he can't do that. He's realised that he's got to try and say that this is within the legal consequences. But what he says is, oh, well, it all depends upon the fact, as he asserts, that Barrowfen intended to keep the property, that it was not said that this was unreasonable on Barrowfen's part, and that the consequence of the cases are that unless there is actually a receipt of money, in which case, as I understand it, he accepts that credit would have to be given for the relevant sum. That's what I understood his submissions to be. Then the legal consequences are that he doesn't have to give credit. So just making the points which I make in response to that. The first point I make in response to that is that it is completely illogical. The intention of Barrowfen cannot affect the measure of loss in this case. The fact that Barrowfen intends perfectly reasonably to keep the property cannot affect the measure of loss, and as I've already said, one can test that by saying, well, suppose you have another, as it were, board of directors of Barrowfen who intend perfectly reasonably to sell Barrowfen, both of them being reasonable decisions. Are the courts really saying that there's a difference of 2.4 million?
Well, it seems a bit odd anyway now, just having thought about what, in fact, this site consists of, because presumably, in a sense, because I assume Barrowfen is not itself a hotel operator, I mean, we're told it's not, then in a sense it'll be granting presumably some operating lease of the property to a hotel operator.
Well, as I said, I can't actually remember the details. It's probably buried in the paper somewhere, but it'll either be a lease or it'll be a management.
And it may actually have to dispose of some parts of the property.
Yes, I mean it may be a management agreement, but the point holds. The point holds good. Yeah. I mean, it's perfectly possible as the owner of a hotel to enter into a contract with a professional manager, so that, I mean, I happen to know that, for example, Hilton hotels are sometimes leased and they're sometimes operated under management agreements. But there we are.
Yeah, but I think your point is that there will be a variety of arrangements entered into with retailers, somebody who's in the hotel business of some sort, whether it's management, operator, or otherwise.
Yes. And there will be a choice of things that you can do in relation to that. You could enter into a variety of different. I've already made.
It's an asset for exploitation.
It's an asset for exploitation, consisting of several different parts which can be exploited in several different ways. So the first is an inconsistency point. The second is a point which my lord made on several occasions. My learned friend opens this as if Barrowfen has got some kind of particular affinity to operating properties in Tooting. Now, Tooting is a very nice part of the world, and there's nothing the matter with Tooting. But the idea that Barrowfen are particularly interested in Tooting, as distinct from if they had the opportunity of doing so for swapping the site with Westfield and so forth, is, with respect, self-evidently nonsense. They are a company which, I fully accept, wants to produce returns for its shareholders. And those returns are no doubt dependent on a whole series of things. But it would be ridiculous, frankly, to suggest that if Prashant Patel was offered £100 million for the property, on the assumption that the valuations and so forth are only out at 47 million, he'd keep on in relation to that and not do so. So his decision, or more accurately, the company's decision as to whether or not to buy or sell this asset is a fundamentally a commercial decision designed to make money for the shareholders. And there's obviously nothing the matter with that. It's to do, no doubt, with his views as to the long-term interests, the fact that he's now got, Barrowfen has now got a substantially greater valued capital asset, and so on and so forth. I mean, just in simple terms, and one can look at the numbers in a minute, he's got an asset which is worth something like, in gross terms, twice as much as it would have been worth previously. So if the value of property doubles, he's going to get a commensurately greater return. And that's fine. There's nothing the matter with that. What there is a matter with is trying to pretend that there is an intention now which governs the measure of damages. My next point, and I'll make this by reference to some of the authorities, this is not a case where Barrowfen was forced to do something particular. At least arguably, it was forced, or at least very strongly constrained, until March of 2021, because it always intended to develop the site. The site wasn't developed, and undeveloped sites are unattractive, and what's more, they're pregnant with developers' profit. If one just reminds oneself of the facts in relation to Harvard's plasticine.
But they're not. So I'm not sure where you're going with this. If you know that this company is holding a property for return.
Yes, of course.
And that it's a property which will benefit from development.
Yes, of course.
And you know that if you...
And sorry, just pausing there, where actually, on the evidence as accepted by the judge, all three shareholders want it to be developed.
Yeah, okay, great. Yep. So your clients know that, in a sense, they can foresee that if they are negligent, that development might be delayed.
Yes.
And so it follows that the actual carrying out of a development, albeit delayed, was within the contemplation of your clients as something for which they would be answerable if they were negligent.
I agree, Mark. Absolutely.
So we've travelled that we've travelled that far together.
Yes. And I was accepting beforehand, and perhaps I should just make it plain, just in case it is of assistance, that during that period of development, the company is also at least constrained in relation to selling the development, because selling a partially complete development is, frankly, a pretty unattractive prospect, which is what I was doing. By contrast, and I'm sure your Lordship has the point, March 2021, the constraints are off and they can sell it or retain it as they want to.
Yeah. Okay.
The point I was going to make about Harvard's plasticine, my Lord's pulled my learned friend Mr. Kramer up in relation to the judgment of Lord Justice Cross. If I could just take you to Lord Denning's judgment, which is at 199. Letter F. The question was raised on the measure of damages. The plasticine company were not allowed to rebuild the old mill, which was 5 stories high, for use as a factory. They had to put up a new factory of 2 stories, but it had no more accommodation. Are they entitled to the actual cost of replacement, or are they limited to the difference in value of the old mill and before and after the fire? So this is a situation where you had a 5-storey old mill in the north of England, and it gets burnt down, and you're not going to be able to replace the old mill. You've got to put in place a more modern 2-storey factory, and therefore, in my submission, this is a case where the company which was carrying out the business not of obtaining money through investment in property, which is at its highest, is what Barrowfen is doing, but is in the business of manufacturing and selling heavy wax products. if it wants to go back into that business, has to replace its property, and it has no choice but to do so by spending the additional money because the planning constraints don't allow anything else. So in our submission, it's completely plain from at least two of the judgments in this case that this is nothing to do with reasonableness and has everything to do with a forced situation.
So it's a bit like having to buy a first-class ticket or having to rent the Rolls-Royce because there just wasn't a Ford Fiesta nearby.
Yes, yes. I mean, yeah. If one go, well, sure none of my lordships ever practiced in the county court, but if one goes back to the one's county court days, and one was before the county court judge, you'd be saying, yes, well, my client had to take the Rolls-Royce because sadly there weren't any Ford Fiestas available. That might have caused some interesting cross-examination, but if it turned out to be true, so be it.
And this isn't really about betterment in a way. It's about, is it repair or difference in valuation, although obviously there was an additional, the thing was better than it was before because it was new. But I wonder whether they really were trying to lay down comprehensive rules about...
Well, it's funny you should mention that, my lord. One of the things which is said in just about every significant case on damages is that each case needs to be evaluated on its own facts. And then what normally happens is this court, or sometimes the Supreme Court, goes on completely to ignore that, or possibly states some general principles and then applies the fact. Can I just remind you in that context of what Lord Justice Widgery said? I mean, and this is all over the place, at 472.
Sorry, do you mean his reasoning is all over the place, or the quotation is all over the place?
I mean, the point I'm about to make is made by numerous other judges in numerous
Thank
cases,
you.
not
Sorry,
Lord Widgery
just
is,
wanted to clarify.
is saying something surprising. If you look right at the bottom of H, he turns to the measure of damage, and he says the distinction between those cases in which the measure of damage is the cost of repair and those in which the diminution in value is not clearly defined. In my opinion, each case depends on its own facts, it being remembered first that the purpose of the award of damages is to restore the plaintiff to its position before the loss occurred, and secondly that the plaintiff must act reasonably to mitigate his loss. And he goes on to deal with that. You can find statements to that effect, as I've said, littered all over the law reports. Can I give you one more example, which is from British Westinghouse, just before we get the most famous citation from Lord Haldane as to the three principles of mitigation which have been chewed over numerously. If one goes to page 56 at tab 3, you see, in order to come to a conclusion on the question as to damages thus raised, it's essential to bear in mind certain propositions which I think are well established. In some of the cases, there are expressions as the principle governing the measure of general damages which at first seem difficult to harmonise. The apparent discrepancies, however, are mainly due to the varying nature of the particular questions submitted for decision. The quantum of damage is a question of fact, and the only guidance the law can give is to lay down general principles which afford at times but scanty assistance in dealing with particular cases. The judges who give guidance to juries in these cases have necessarily to look at their special character, and to mould for the purposes of different kinds of claim the expression of general principles which apply to them. This is apt to give rise to an appearance of ambiguity. Subject to these observations, I think there are certain broad principles which are quite well settled. I remember very well a case in which I lost before His Honour Judge Harris, DFC, in the Westminster County Court for the grand total of £8,750. I advised that we had unassailable appeal to the Court of Appeal. My clients didn't believe me and took an opinion from Mr. Tilson, who said the same. That we went to the Court of Appeal and we lost on the basis that we were right as a matter of logic, that the Court of Appeal was bound by a decision in 1934 where the point hadn't been argued. We then went to the Supreme Court, the House of Lords, and the other side didn't turn up, of which their lordships took a dim view. And Mr. Toulson started off by quoting that general proposition. And my lord, if ever there was a case, frankly, to which that principle is applicable, it is this one. This is a funny old case, frankly. It's got numerous respects in which the judge, sometimes to the chagrin of my clients, sometimes to the chagrin of my learned friend's clients, came to detailed and balanced conclusions in relation to various matters. But when you stand back and say, what's the loss for which they're being compensated for? Answer, they're being compensated for not being able to develop this site for a maximum of 55 months. What happened as a result of that? Well, they didn't get rent for 55 months. They had to pay £399,000 by way of additional sums of money. But at the end of it, they got an asset which, as compared with what they would have had previously, was £2.5 million more. And you look at that in the round and say, what's the matter with that? And the answer, I say, is nothing. And if a jury, and in this respect, with respect to the fact, of course, we were in the Chancery Division, so one wouldn't have had juries there in any event, but if a jury had come to this conclusion, having been given an appropriate direction of law, it would have been utterly unassailable, which may be one of the reasons why, if one looks at the American law reports, one sees rather fewer cases on the measure of damages than one does in relation to the English law reports. Anyway, I digress. Having then looked and established what the legal principles are, I say that the first legal principle is to be summarised in the important decision of Fulton, which is at tab 7. And my learned friend has already taken you to the relevant passages. But can I just emphasise what I rely on from the judgment of Lord Clark, which is at paragraph 29, starts at paragraph 29 on page 176. And he starts by saying that, viewed as a question of principle, most damages issues arise from the default rules which the law devises to give effect to the principle of compensation, while recognising there may be special facts which show the default rules will not have that effect in particular cases. Something of an echo of what I've just been showing you. On the facts here, the fall in value of the vessel was, in my opinion, irrelevant, because the owner's interest in the capital value had nothing to do with the interest injured. That can't, in my submission, be said here. The whole purpose of carrying out the development was to develop, that is going to produce a completed scheme at the end of it. This was not because the benefit must be of the same kind as the loss caused by the wrongdoer. In this regard, I agree in principle with the 8th proposition set out by the judge. As I say it, difference in kind is too vague and potentially too arbitrary. The essential question is whether there is a sufficiently close link between the two and not whether they're similar in nature. The relevant link is causation. The benefit to be brought into account must have been caused either by the breach of the charty party or by a successful act of mitigation. And I say that is the fundamental principle here. That's what has to be taken into account. And in my submission, my learned friend misreads the authorities in trying to assert that something which can be turned into cash can sometimes be said not to be cash simply because it is not sold, which is the effect of what it is that his primary submission was.
So I'm clear, when you say that's the governing fundamental principle, the benefit to be brought into account must have been caused either by the breach or by a successful act of mitigation. And on your case, the benefit is the better capital value of the development.
Yeah, and that's brought to echo a point your lordship made to my learned friend by what your lordship referred to as factual mitigation. They did this because they sought to make their position better off. I accept that's what they did. They did do it. They claim that, and the consequences have to be brought into account.
And of course, there Lord Clark says, or by a successful act of litigation. And in this context, not that it is relevant. It's not a question of whether they were reasonably obliged to take any step. It's enough that they took this step and ended up with a better result.
Yes, and my lord, there are cases which show it would have been very difficult for me to challenge a decision either to go ahead or not to go ahead with a development. I mean, probably if they'd sold the site, they would have produced good reasons for it. I mean, in other words, there are, because of the breadth of the extent to which the law is prepared to allow people who are innocent to make reasonable choices, you can have two different parties, one of whom will reasonably be held to have done something, and another whom will be held reasonably not to have done something, both of which will sound, as it were, in mitigation. But just because they did something reasonably doesn't mean that if they didn't do it, they would be acting unreasonably. That's the important point. And so, I think I've said this already. If I haven't, I'll say it. Well, if I have, I'll say it again. If I haven't, I will say. Their case depended on saying they'd mitigated, the mitigation being the change in the planning consent, the delays and so forth. That's reasonable. They can't be heard to say it's not reasonable. They can't be heard to say it's not legally caused. And that's where we are.
So is this right? You'd say that if an increased capital value of an asset, and we'll come to the question of the extent of how that's made up in a minute, but if the increased capital value is caused by, is a benefit flowing from a step taken in mitigation of loss, in a way that can be said to be caused by it will be taken to be caused by the breach, and therefore
well either by the breach or by the act of mitigation.
Yes, it's either or both. Yeah.
It's the result, the fortuitous result of the mitigation that was in fact taken.
Yes, I quarrel with the word fortuitous because of the consequence. It's the result, not fortuitous result.
And you say that, and you say that's the same, irrespective of whether it can be reduced into money.
Yes. Well, sorry, it's irrespective as to whether or not it is in fact reduced into money. I don't for a minute say that it's irrespective of whether it can be reduced into money. If you can't reduce something into money, then you've got a lack of an available market, and as it were, different rules apply. But if you can sell it, then yes.
Well, it's the sell bit. I mean, the value. Sorry, keep coming back to this like a dog with a bone, but the developer's profit that this is all about stems from essentially, to some extent, an assessment of what this property could be sold for, or at least the discounted receipt of money.
Yes, can I? I've been promising you for some time to show you the valuer's report, and I think it might be helpful if I were to do that and then answer your lordship's question, if I may.
So we can leave Fulton.
You can leave Fulton, my lord. I've got legal authorities, but I'm proposing, if I may, yes, in answer to your lordship's question about what actually happened, Barrowfen actually entered into a 25-year lease with Premier Inns. That's the reference is Prashant 4, 182A, and it's the supplemental bundle, tab 3, page S20. But the valuations, for reasons I can't now recall, can probably find out overnight, proceeded on the basis that Travel Lodge would be the tenant, and there were also restaurant and shop leases. Now, my lord, what I'm going to do is to show you the supplemental expert report of Mr. Alford. The reason I'm doing that is that the judge didn't accept all of the figures from either expert, but they approached the matter in broadly the same way. By taking the claimant's expert, it can't be said that I'm trying to look at the matter from the point of view of my clients. And secondly, or thirdly possibly, the judge on the whole went more with Mr. Alford's figures than he did with Mr. Clark's figures. He didn't go entirely one way or the other. Can I just show you various parts of this? The first is on page S73. Actually, if we could just start at S72. In this expert report, Mr. Alford took the opportunity to make some revisions to an agreed statement which had dealt largely with rents. And he then sets out the new figures for rents, and those include the amended original development on S73. And you'll see that what he finds in relation to the various different rents is there are rent-free periods and a need to rent out the retail, such that the retail rents only start in months 6 to 12 at 233 odd thousands. The hotel has a similar profile, and then one sees the community housing, and one then sees the two different categories of student housing. And he then values the original development, and we don't need to look at that because the judge proceeds on the basis of the amended original development, which you find at page S76. And the detail behind the amended original development is to be found at S81. And if you could, just as it were, put a finger between the figures at S81 and S76, you see the residual report at S81, and the first thing he does is value the hotel, and he does that based on an estimated rental value and a yield of 5.25%, so as to come up with a capital value. For student housing, he does the same with a rental value and a yield of 5%. The community housing, he does at the same. The retail units at the same. And the facade, which is just space, comes up to nothing. And so going back to the first page, the residual, the gross development value is there set out, and then he deals with the costs of construction, and included within the costs of construction are finance costs, which are divided.
Just before you do that, I've confused myself. The figures at S81 don't tally with S76, do they?
Your Lordship is looking at the difference between 29,235,000 and the 200 and
Right.
7,342. They don't, and there's a reason for that, which I've forgotten.
The reason is he should go to S83, I think, rather than S81.
That's, my lord, not for the first, and I'm sure not for the last time. That's right, he makes a correction, that's exactly right. And it's a correction which is made in this report. I'm sorry, it's S83.
Yes, I think.
I'm grateful, thank you. And just while we're on S83, he's got assumed build costs with build rates, and then you've got fees and so forth. But over the page, S84, he builds in funding costs, and you see that he's assuming no equity, 100% new loan with an assumed funding level of 4%, and it's over the period of the assumed development. In other words, from January 2015 until September of 2016, and comes to 640 odd thousand.
So that's a cost to be deducted when you're working out the gross valuation. Okay. So he's built in an element of future financing costs for the whole lifetime of the development, has he?
He's built in the costs which are attributable to financing during the period of the development,
Yeah.
which comes to an end at the point of completion of the development in September of 2016.
Right, okay.
It's part of the calculation of getting you to the finished product.
Yeah.
Yes, it is. And your lordships will know that this is a standard spreadsheet. It's a residual value calculation. You will always have this being put in there, and you plug in a number, and out comes the answer. And just to be clear, what he was saying the developer's profit was, the judge doesn't agree with this, as you'll see in due course, but just so you can see his methodology, it's 29.2 million less 17.187 million, and he breaks down the cost of construction, 14 million, professional fees, marketing, letting, finance, and you get to that difference of 12.048 million.
So implicitly, what you could sell it for is 29 million.
You could sell the whole of the site for £29 million. That's exactly right. And you then obviously, in order to get what you get from it, you've got to take off the costs which you've achieved in order to get that.
Yeah.
Now, the revised development scheme is then treated in the same way, and that starts at S76. Now, just to be clear, as you perhaps would expect, Mr. Clark had given figures where the difference between the two schemes was substantially more. Mr. Alford gave figures which were actually on a lesser basis, and the judge ended up coming to factual findings in relation to them. But I'm only showing you this not because these are the final figures, but to show you how the matters was made up. And one sees the developer's profits calculations at S77, and the equivalent sheet, which we've just been looking at, is that which is to be found at S85. If we could just go to S85, the biggest single change that you've got here is that for the residential units, which are, I think, 1, 2 and 3 bedroom flats, they're being done on a square metre basis for sale. And so you see residential private sales, 23,360, value per unit 767, and when you multiply those out, you get 17 million odd pounds. And you also see social housing being being valued on a sale basis. The remaining items, the hotel, the retail, and the community space, are valued as before on a yield a yield and rental value basis. And if you look at the financing costs at S86, he estimates those at 1.21 million. This he's put in as 100% equity for reasons I can't now recall. It probably doesn't matter, but he's put it in at 4% with nothing on a new loan. And his calculation would have been that the developer's profit on this scheme was 11.964 million, and so it was actually less than the figure put forward for the other scheme, and the judge rejected that, as you can see from his judgment. But for our purposes, the important points are really threefold. The first is that the actual developed value of the scheme, even on the defendant's case, was very substantially greater, some £39 million as opposed to £29 million, and on the judge's figures still more. So you'd actually got a development which in broad terms was 1/3 more valuable. Secondly, as found by the judge, there was also greater developers' profit. And thirdly, in the revised scheme, you had actually got flexibility in a way which you hadn't got on the original scheme, principally because of the inclusion of the residential housing, which you could do what you wanted with. So it's not at all surprising that Barrowfen, Patel and so forth wanted to keep this scheme. They've got a, on their own case, £40 million scheme in Tooting. If the value of property doubles, they'll have something worth 80 million, whereas previously if the value of properties had doubled, they'd have something worth 60 million on those figures. Lords, would that be a convenient
Yes.
moment? Well, just to help you, I think
Yes.
I'm going to probably be, I should think another 3/4 of an hour tomorrow, possibly an hour actually, when I deal with my appeal, and then you'll be hearing from Mr. Folcard. I would hope that we would finish our combined time very shortly after lunch, so I don't see any difficulty at all as far as we're concerned with the time. We'll certainly finish within, if I can put it this way, a day of when we started this afternoon.
Good. So 10:30 in the morning.
Thank you very much.